so-called insufficient samples. The significance of that. Well, you have to know what that's all about. So you need the manual from the machine itself, not the one the state police publish, because that's proprietary, excuse me, because that's what they want you to see. It's part of their infrared breast testing course. All this stuff is foreseeable that it will get into the defense hands. It's all very self-serving. You want the one that the machine manufacturer publishes that talks about all of the warranty claims and all the disclaimers and all of the added options. If you don't have this, you can't do this. You don't have a mouthpiece that does such and such, you can't do this. You want all that stuff. Think about cross-examination on this flawless, perfect, wonderful machine where they're changing the models every 6 months because of their new and improved versions, okay? So all of this is discoverable. If you have a blood case, you want the chain of custody, you want the protocols, you want all the stuff that involved with the blood. There's a whole issue on blood. And Kevin will talk very briefly. By the way, this is Kevin Reddington, see this distinguished gentleman sitting right there? He sat the longest with his mouth shut that I've seen him since I've known him. But he will enlighten you on this, and I'm gonna have him join in a minute on the discovery business. So, be as creative as you can as long as you can tie it into relevancy. As I said, audit sheets are very remarkable in telling you who the police are and what they're all about. You want to know everything that the defendant signed. You want everything that relative to the case. Plus you want the log. It's something called an administrative journal. Boston Globe sued the police departments in the past and was successful to show that that's a public record. So they're not giving up anything. So you're entitled to a non-redacted version of the log in the administrative journal because it's a public record. Now, why is that important? Because it gives you, it gives you roll call. Simple thing like roll call. You want to know how long the cop has been up? You might be on a second shift. He might be up for 24 hours straight. He's blurry-eyed. He doesn't write his report till 3 or 4 hours after that. You want to know that. You want to know where the other officers are. You want to know if they're on other calls. You can say, I was assisted by Officer such and such, but he was on the other side of town, according at least to the log, and the log never lies. The police are laughing up there. They know that the log never lies, right? Anyway, the point is, you want this stuff, and you might want to run it by some law enforcement friends. They have them interpret it for you. You'll find out stuff, but they can look at things and say, wait a minute, this isn't right because of. Just like you use an expert witness as a doctor who can interpret things on a medical report. They'll see things, if you're new at this, on a police report that you might not be obvious to you. Okay. Any questions on discovery itself? Because I want to have Kevin join in on this, but on the issue of discovery. Everything relevant is discoverable. That's the test. Not burdensomeness, not onerousness. The second part of it are motions in limine, and I won't get into the motion in limine on the .08. You've already talked about that a little bit. I try to find a reason to file a motion in limine in every OUI case. What is a motion in limine? A motion in limine is asking the trial judge to make an evidentiary ruling prior to the start of trial. So what does it do for you? It gets you to talk to the judge. You might go there. I don't know about you folks, but I go all over the state trying these cases, and half the time I don't know the court. I'll have to go to Springfield. I'll have to go to Palmer. I'll go to courts that I never knew existed, Orange. And I don't know these judges, and sometimes I call local counsel to find out what they're all about. But it also gives you credibility. You file a motion in limine on some issue, asking for an evidentiary ruling. The judge can do one of three things. One, can allow it, and that would exclude comment on it by the DA. Two, can deny it, which would allow comment on it. Or three, reserve. In other words, not making any ruling, waiting to see the context in which it comes in terms of trial. But what does it do for you? It starts the rapport. It starts the credibility. You have to have credibility with the court before you ever get to establishing credibility with the jury. You want the court to know that you know a little bit about this stuff, and that you're respectful, and that you get a sense by that initial talking about it. I try to do it in the lobby, although a lot of places don't do lobby conferences. But I try to do it in the lobby. It's much more informal with the DA. And you schmooze. And the next thing you know, you got some kind of a rapport, you've built up that credibility, and I use it through the vehicle of a motion in limine. Now, motions